I'm Cynthia Rowland, and this is episode 39 of EO Radio Show. This week, I'm going to cover important issues for nonprofits who are dealing with distressed businesses, such as their landlords or their tenants, other kinds of contract counterparties, and somewhat recently, banking institutions or financial institutions in particular. We'll talk a little bit about warning signs to watch for, some ideas for managing the situation when a party seems to be facing financial distress that affects their ability to perform, and when to call a lawyer for help. And for this specialized area, I'm joined by my partner, Gary Kaplan, who brings deep experience with bankruptcy laws and creditors' rights to our discussion. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. My guest today is my partner, Gary Kaplan. Gary is a highly experienced bankruptcy lawyer with expertise in a broad range of insolvency issues, representing both debtors and creditors. His practice includes advising clients to best protect their financial interests, negotiating a wide variety of transactions, and litigating complex matters. Gary began his career as a financial analyst on Wall Street before attending law school at UCLA. He has over 30 years of experience and is a certified bankruptcy specialist. Hi, Gary. I've been looking forward to discussing this topic, which is now, unfortunately, pretty timely as the economy is a bit rocky in a lot of respects in a lot of places. I'm glad you could make time for us today.
Thank you, Cynthia. I'm happy to be here.
This is a pretty specialized practice area. Tell the listeners a little bit about your career trajectory and how you ended up specializing in bankruptcy and creditors issues.
Sure. I went to a business school undergrad at the Wharton School, and then I worked on Wall Street for a couple of years and really was interested in financial issues, but then decided to go to law school. And while I was in law school, after taking a basic bankruptcy class, I took an advanced seminar with this professor named Ken Clay. And Ken Clay had written the bankruptcy code actually with one other individual back in 1978, the U.S. bankruptcy code that all the courts in the U.S. now use. And he made the topic so interesting. And the way we proceeded in the class was we had a hypothetical company that we took through a Chapter 11 bankruptcy. And it was a real world experience. And I really liked it. And after I graduated law school and started working at a large firm, I asked to try to do bankruptcy work to see if I'd like it in real life. And I ended up liking it and kept doing it ever since.
And so here you are. So there's nothing like learning from the people who wrote the law. I guess I didn't realize that bankruptcy law was that young. I mean, 78 doesn't seem that long ago to me.
Well, there actually is bankruptcy law going back hundreds of years, to England even before we were colonized. But there was a code that was passed in the 1890s, but it really needed a lot of reworking. So that's why in 1978, Congress essentially redid the whole thing for the modern economy.
What was modern then, I suppose. What's modern now is even a far cry from that. Tell us a little bit about warning signs that nonprofits should look for. And I guess to preface this for listeners, we're talking about nonprofits and bankruptcy and creditors issues when the nonprofit is healthy and its counterparty is suffering. The topic of nonprofit bankruptcies themselves we'll save for another day. So today, just thinking about a nonprofit client, what should they look out for with their business partners to know when they should be on alert, when there's a red flag?
Yeah, there's a few different warning signs a nonprofit, just like a private business, should be aware of. And it's things like if the other party to the contract is delayed in getting their performance done, their work done, whether it's delivering goods or providing services or using donations for a particular purpose. Those sort of things are usually red flags. If the nonprofit is owed money by the other entity, as often happens, and those payments are late or the full amount is not coming in on a regular basis, that's usually a big red flag. Also, things like requests to redo deal that the parties have, redo an agreement to try to buy some more time or get some more money from the other side. That's usually an indication that they're in trouble and they're looking around to try to find ways to get money here and there. For nonprofits in particular, I think one of the biggest red flags is if they learn that there were funds that were donated to an entity for a particular purpose, and the money's not being used for that purpose, it's being used for something else. That's usually an indication that there's real financial trouble, and you need to look into that further. And just common things like if it looks like for some reason you're not getting responsiveness, where parties are not returning calls or emails like they used to, or texts, that's often a sign that they're in trouble and that they're otherwise preoccupied and they might be having financial issues.
Yeah, so cash flow red flags too, thinking about they've got the resources, but they don't have the cash flow, excuses like that.
Exactly.
And I've seen that for a nonprofit that's dealing with another nonprofit that starts borrowing, I'm using air quotes, from their endowment to pay operating costs, things like that just seem a little bit odd.
Absolutely. Once you see things like that, that is definitely the sort of thing where bells should be going off that there's a problem there. Paying borrowing Peter to pay Paul. Yes,
exactly right. So, what can the nonprofit do to reduce its risks? So it's got some red flags. Some important business partner seems to be distressed. Any advice on trying to protect our client, the nonprofit, on the one hand, or figuring out an exit strategy? I guess.
Yeah, there's a few things that a nonprofit can do to try to be proactive. First, things like just making sure that money is being used for its intended purpose. So, for example, a donation that's been earmarked for a particular project, to get confirmation that that's actually where the money is going. And then, especially if you're talking about a large amount of money involved here, asking for financial statements for the other party and regular reporting from them, and including their profitability and their bank statements. That sort of thing is fair to ask for, especially if there's a big credit risk. If the nonprofit is paying out a lot of money or is on the hook for a lot of money. Those are fair things to ask for at a time. And then just some of these are sort of common sense things to stay on top of deadlines. If the other side's supposed to be performing an agreement by a certain date and those dates are slipping, it really makes sense to push them, essentially be the squeaky wheel and make sure that your particular project or matter gets first priority. And now sometimes you can't help it. Things come up and the other side will ask for changes to the deal to try to make things work if they're having financial problems. And in that case, a lot of times these are done over the phone. It's handshake sort of things. But you want to get everything confirmed in writing, because there's problems later. Just saying that somebody said something on a phone call is not going to do it. Even an email confirmation of what was agreed to is an important thing. And especially email confirmations of if there's a promise, don't worry, we're going to pay you by Friday, or don't worry, this delivery will come in on Monday. You want that to be confirmed in writing and essentially have a paper trail. If you really feel like the other party is having cash flow issues, you don't want to be doing things like prepaying for goods or services unless you have appropriate protection. Either the money's being put in a segregated account, or there's some sort of escrow set up, or some other arrangement, or pay COD, cash on delivery, for things. But you don't want to have cash be at risk with an entity that's in trouble, because they may use that money for something else. In a big enough case, it makes sense to ask for some other source of financial backup. That could be a guarantee from a parent company or a wealthy individual, or getting what's called a letter of credit, which essentially is a bank backing up another company's obligations. Or, in the case when you're dealing with the sale of goods, you can get a security interest in the actual property. So in other words, if you're selling goods to someone else, you don't want to sell them just and hand them over. You want to say, we have a security interest or lien in those goods till you pay us. Now, sometimes these transactions won't involve goods. There'll be something else. In that situation, you can do the same thing. You can get a lien, or what's called a security interest, in other assets. So, for example, we have recently helped a client with a nonprofit that owns a very expensive piece of artwork. And we took a security interest in that artwork as security for the obligations they owed the other nonprofit. So that's another way to try to get some protections.
And some of those things, if the contract is big enough for our nonprofit client, maybe they will get legal help in drafting the contract. Sometimes they don't. And when you see these things going a little bit sideways, is it fair to approach the other party and say, hey, it looks like you're being late in payments. Let's renegotiate the contract and add provisions things like this. Is that fair to you, or is that just too bad your contract didn't help you and now it's too late?
I think that is fair. And in fact, under the law, there's an ability to ask for what's called adequate assurance if you have reason to believe that your counterparty is not financially viable or not likely to be able to perform. So that's under the law. And as a practical matter, it happens all the time where the facts on the grounds change and there's concern about performance and parties rework the deal and add some protections to address that. So I think that's a totally fair ask in that situation.
So let's suppose things have gotten worse. We saw the red flags. We didn't do anything about it. And now we suddenly find out that the business is insolvent or has filed bankruptcy or something like that. What does that mean? How does that change the playing field if they've reached that point?
It really depends. This is where it gets a little bit complicated. It really depends on what happens to them. If a company files bankruptcy, there's certain rules that govern that. There's other proceedings that are similar to bankruptcy. And in common parlance, people think of them as bankruptcy, but they're different and they have different procedures and rules. So let me just quickly run through a couple of those. One of the ones that often comes up is a receiver is appointed to take control of a distressed company's assets. And a receiver is like a bankruptcy trustee, but it's not the same level of control and power that a bankruptcy trustee has. And a receiver essentially is babysitting property for a set period of time. And there's special rules that go along with trying to get paid from a company that's in a receivership. That's one type of proceeding that's like bankruptcy, but not really bankruptcy. There's something else called an assignment for the benefit of creditors. And what happens there is the distressed company actually turns over all of their assets to a new entity. And it was called an assignee. And the assignee is in the business of doing this. They take control of all the assets. They try to liquidate them, turn them into cash, and they pay off all the creditors of the entity. People sometimes call that an ABC, an assignment for the benefit of creditors. That has also special procedures, including having to file a claim in the case with the assignee, the party that's taking control, to say how much you're owed and get your pro rata share of whatever's left. Another type of proceeding is called a dissolution, and that's essentially a proceeding where the company is closing its doors. It is just going to stop operating, file some paperwork, and just goes out of business. But there's also procedures for that, for creditors to file claims, and there's requirements that the company must pay all the claims they can from the assets that they have and that get liquidated and turned into cash. But there's also rules that govern how long claims can stick around there. In that situation, there may have to be a reserve set up, for example, for claims that are contingent that have not been determined yet, like litigation type claims. That's another proceeding that it's not quite bankruptcy, but it's similar to bankruptcy. But for all these, the one thing that I think is uniform is that once you hear that your counterparty is involved in one of these proceedings, the first thing you want to do is get as much information as possible so you understand what's going on and what you need to do to try to protect your rights. In a bankruptcy situation, it's more formal. There's actually a case docket. You can go online and look at the papers that have been filed and get a lot more information that way. In a less formal proceeding, let's say like a receivership or ABC, an assignment for the benefit of creditors, there's usually a website that's set up by the receiver or the assignee for creditors to get information. And a lot of times, even in the bankruptcy situation, not only is there an official court docket that has all the papers filed, but there's a separate website set up that has more information about the case and what's going on. So first, it makes sense to get up to speed as much as you can with this information. Now, some of it, if you're a creditor of one of these distressed entities, you're entitled to get this stuff by either mail, regular mail, or email, some of the papers that get filed in the proceeding, but not all of them. So that's why it makes sense to be proactive and try to gather as much information as possible. The second thing you probably want to do is stop spending good money after bad. So, for example, if the nonprofit's in a deal where it has to either commit money or send goods or provide services, and there's not assurance they'll get paid now because their counterparty is going through one of these proceedings, usually makes sense to suspend performance. Now, you have to be careful here because if the entity is in bankruptcy, there are special rules that govern what you can and cannot do. There's something called the automatic stay that goes into effect when a company files bankruptcy, and it prevents other parties from suing them or taking any actions against their property. And that actually includes, you cannot, for example, terminate a contract with a company that's filed bankruptcy, even if the contract says if you file bankruptcy, we can terminate the contract. You can't terminate the contract. And that violates the automatic stay. But the tricky line is what you can do is suspend performance and say, hold on, we're stopping here. We need to find out if we're allowed to terminate the contract. And usually you can either get agreement from the other side, or you can go into court and say, we want permission to terminate the contract because we're not getting paid or they're not performing. But you still need to take that step in the bankruptcy case.
Two questions that come to my mind. One is, so it's my landlord who's going bankrupt. Can I just stop paying the rent? I'm guessing not if I'm going to stay in the building. That's one of those examples where you don't get to just terminate that.
True. Yeah, good point. You must keep paying the rent if you want to stay in the building. Or another way of putting it is, if you don't pay rent, the landlord has the same rights they'd have if they were not in bankruptcy to try to evict you if you don't pay rent. However, what you can do is set off, if, for example, there's repairs that need to get done that have not been done, you have to come out of pocket to do it, you can set that off against your rent. You certainly don't want to be paying, and I should have brought this up earlier, if you deal with a landlord that you think's in trouble, let's say you're entering a new lease, you want to make sure if you give them a security deposit that money is protected. It's segregated in a special account. It's not going to be mixed up with all the other funds that the landlord has, because later on, when you want to get your security deposit back, you want to make sure the money's there.
And that reminds me of another point. So not in a landlord situation, but I'm the counterparty that's distressed, owes me money. They wrote me a check and put it in the snail mail and I got it, but it's such a pain and I haven't gotten down to the bank, for whatever reason. And I find out they're in distress. Can I just go cash it now or get them to prepay me, send me some money? It's my good friend. And I know from inside stories that they're facing some rocky situation. I'm like, well, just pay me. Okay. I know, and not everybody's going to get paid. Can you just pay me quick?
Yeah. So I think a couple issues come up there. So first of all, yes, I would, run, not walk to the bank to cash that check if you think they're in trouble. Second, unfortunately, if they file bankruptcy, usually the accounts get frozen the moment they file bankruptcy. So outstanding checks just won't get paid. If it's not bankruptcy, sometimes you can still get it through. The third is there's this risk that if you got paid from a company right before they file bankruptcy, you may be asked to return that money as a so-called preferential transfer. And there's always that risk that could happen. But I generally tell clients, you should take the money anyway. You may have to give some or all of it back later, but better to take the money now versus refuse it just because you might have to give some back later. So I think that makes sense to do on the preference front. And then back to dealing with companies that are already going through, let's say, a bankruptcy or something like it. If you want to keep doing business with them, you want some assurance that you're going to be paid for your at least ongoing work. You may not be able to get paid for things that were owed prior to that proceeding, because usually there's a fine line drawn when let's say a bankruptcy is filed, and amounts that are owed prior to the bankruptcy are treated differently than amounts owed after the bankruptcy. But for the amounts owed after the bankruptcy, let's say for services the nonprofit provides to somebody, they want to make sure they're going to get paid. In the bankruptcy world, there's a way to do that. You get what's called an administrative expense, which is a higher priority claim than regular pre-bankruptcy debt. You want to make sure if you're dealing with a company in bankruptcy that they acknowledge that the amount they owe you is going to be an administrative expense. And likewise, in the context of a receivership, there's also ways to get essentially the same treatment, to get preferred payment priority for dealings after the proceeding that gets filed. But you want to make sure that they agree to that before you continue to perform under the contract.
So if I'm the nonprofit landlord and one of my tenants is distressed and I want to make sure that I'm going to continue getting paid, that's a situation where you might go this route.
Exactly. That's a good example. And I mean, there are also additional protections, at least in the bankruptcy world, that require a tenant in bankruptcy to resume rent payments soon after the bankruptcy is filed. Otherwise, they can be kicked out of the lease. But that's only in the bankruptcy scenario. That's not in the other proceedings. So, what you just mentioned is probably a good idea in any event.
I suppose for many of these issues, the nonprofit's regular business attorney would be a great help. But talk a little bit about specialized counsel that really that's deep in the trenches on these creditors' rights. When is the right time to call an attorney when these red flags are waving?
Yeah, no, I'm happy to answer that. Before I forget, I was going to add one more point about once you learn your contract counterparties in trouble or in bankruptcy, what next? And at least in the bankruptcy world, there is this concept of executory contracts, meaning at the time of a bankruptcy is filed, if there's a contract between the company in bankruptcy, the debtor, and the other party, let's say the nonprofit, that still has material performance outstanding. In other words, there's still a lot for each side to do. In that situation, if the debtor in bankruptcy assumes the contract, in other words, ratifies it, takes it on, that is a big benefit to the counterparty because that requires not only for the debtor to keep performing, but they have to pay all the defaults, all the arrearages that are owed under the contract, even from prior to the bankruptcy, which is unlike the usual situation for a creditor in bankruptcy. So one thing you want to do if you're a nonprofit, and if you have leverage, the debtor in bankruptcy really needs your contract, the work you're performing for them. It makes sense to push hard and say, well, I want you to assume this contract in the bankruptcy. I want to get this protection. Otherwise, we're not willing to continue to work on this or continue to come out of pocket on this. So that's one thing to be aware of. And that does tail into the last question you asked, which is, when does it make sense to talk to a specialist versus just a regular business lawyer? I'd say almost no matter what, if the other entity files bankruptcy, not one of these other proceedings, but bankruptcy, which is really a world unto its own, you probably want to have bankruptcy counsel help you because there are all these traps for the unwary and all these what seem to be counterintuitive rules that govern things. Like I mentioned before, the thing that says you cannot terminate a contract when the other side files bankruptcy, even if the contract says just that. So those sort of things, are things that really a bankruptcy attorney will know and other attorneys might not know. So it usually makes sense to do that. And then if you're talking about any sort of substantial amount of money involved or goods or services that the nonprofit is going to have to devote to continuing to work with the company in trouble, it probably makes sense to get counsel involved there because there's at least some protections that bankruptcy counsel or insolvency counsel can help you build in to that relationship that you might not otherwise think of or that the business lawyer might not be aware of. And even though, it's obviously it's an expense to do that, to hire counsel to do that, but a lot of times it's cost effective because it'll save you enough money or get you enough money in your pocket that you otherwise wouldn't have had. It ends up being money well spent.
Kind of start wrapping this up. Do you have any thoughts on the most recent trigger of distress, at least in my little universe, the financial institution that's in distress when the bank seems in a rocky situation? Any thoughts on how nonprofits should feel about that or approach the distress at their own financial institution?
Yeah, no, it's a good question. And, until recently, it's something that we didn't think of very much. We just didn't think of our banks failing. And now we've seen a couple in a few weeks fail. Obviously, Silicon Valley Bank is the one that people know the most about. The rules are legally deposits are only protected up to $250,000 with an institution. And after that, they may or may not be paid off. Now, in the case of these two banks that just failed, Signature and SVB, the FDIC agreed to make everybody whole, all depositors above 250 also. But that's not always the case, and that may not be the case next time. So you should have the working assumption that if you have more than $250,000 in an account, it won't be protected if the institution fails. And this is a bit of a quandary because a lot of banks will say that they will only lend money to customers, the business customers, if the customer does all the banking at that bank. And a lot of times then you're going to have more than $250,000 on deposit at the bank because that's just the nature of the business. So in that situation, I think it makes sense to either push back if you're going to be having a lot of funds at that bank at that time to push back on that provision. Obviously, it's a dicey issue because you're basically telling your bank, I'm worried about you failing. I don't want to lose my money with you. But it's a fair ask in terms of what's gone on recently. The reason there was this flood of money coming out of SVB that led to its failure is because its customers were forced to leave their money there, the business customers, then they got panicked and all took it out at the same time. So I think it's a fair thing to ask for. Now, you can also do what you do with contract counterparties, which is you can monitor the bank that you do business with to see if they're in financial trouble, what their asset portfolio looks like. Are they sort of betting the house on one particular industry like tech in a way that there's real risk there? If you look at this, if you're banking with Citibank, JP Morgan, you don't have to worry about this. Those banks, they are, quote, too big to fail. The government will not let them fail. But for other banks, you might want to be cautious about leaving more than 250 in there if there's any doubt as to their financial strength. And unfortunately, that's not a great answer, but that's the best you can do.
Yeah. And I think for a lot of nonprofits, there's also the ebb and flow of funds. You need enough in your bank account to pay payroll, and payroll is more than 250. And so, how do you manage that? And I think we could do a whole episode on banking and investment funds and how to protect them. but there's sweep accounts and ways to make the excess amount get dispersed among other financial institutions. So effectively, you're protected. But there's a lot of different ways to tackle that. Any closing comments or closing thoughts that came to your mind as we were talking, or other resources that you would direct listeners to learn more?
A couple of things. The first, I know we all get inundated with paper, but if you receive anything in the mail or email about someone you do business with, even if it looks like a bunch of legal jargon, it makes sense to read it or pass it on to your lawyer, because a lot of times it really can impact your ability to get paid. And people don't realize it because they get a stack of paper. That's an important thing to learn about. And then I think there's a couple of links that we have to some publications or other webinars I've done that also shed light on some of these issues. Hopefully there's a way to share that with listeners.
Yeah, absolutely. So we'll put that in the show notes. So it'll be easy for listeners to find it on the EO Radio show notes for this episode. I've sure learned a lot. I always do when I talk to you, Gary. I can see how it would become a fascinating area because it's a very technical set of rules, and parsing through them and applying usually what's quite a dramatic story for one organization or another. I can see how that would be a fascinating way to help people solve their problems.
Thank you, Cynthia. I really enjoyed talking with you.
So with that, we'll wrap up today. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.